Over the next 2 days, we'll explore a wide range of topics on reforming the dispute settlement system of the WTO. Who better can explain what will happen over the next 2 days than the person who conceived the idea of this conference? So, may I now invite Dr. Kapil Sharma to give the introduction of the conference? Thank you.
Thank you, Lakya. So, good morning, all of you. I warmly welcome our Honorable Vice Chancellor, sir, Professor Shri Krishna Dev Rao, Justice B.P. Jeevan Reddy, sir, esteemed guests, both on and off the dais, Registrar Professor Vidyalata Reddy, ma'am, colleagues, and dear participants, to the two-day international conference on crisis and solutions to dispute settlement system under WTO. This event is organized by Justice B.P. Jeevan Reddy Center for International Trade and Business Law in collaboration with the Center of WTO Studies at the Indian Institute of Foreign Trade. As we gather here on this momentous occasion, it's my honor to introduce this conference, a pivotal platform for addressing one of the most critical challenges in international trade today, the crisis confronting the dispute settlement system under the World Trade Organization and its reform process. The dispute settlement understanding of the WTO, often referred as a crown jewel, finds itself at the crossroads. The blocking by the United States in appointing and reappointing of appellate body members has eliminated the intricate and dynamic nature of global trade. Recent years have seen the appellate bodies functionally severely compromised, becoming a defunct institution and underscoring an urgent need for reform and the adaptive strategies to revitalize the dispute settlement system. In response, members from 2019 onwards have been diligently working towards resolving the current crisis. A temporary solution emerged in the form of multi-party interim appeal arbitration arrangement in 2020, intended to keep the wheels of the two-tier system moving. However, the quest for the permanent solution continued. Reflecting this, the 12th Ministerial Conference outcome document saw members agreeing to establish a fully functioning dispute settlement system accessible to all members by 2024. In 2022, the United States initiated informal discussions on DSU reform, fostering hope that by the 13th Ministerial Conference, a fully operational dispute settlement system would be at place. Yet, following the conclusion of 13th Ministerial Conference, we find ourselves still in pursuit of this goal, with members once again adopting a ministerial decision that acknowledges the progress made towards a fully and effectively functioning dispute settlement system by 2024. On that background, therefore, this conference is more than a gathering. It's a vibrant call to collective intelligence, a unique, united quest for innovation, and a sincere endeavor towards solution that will shape the future of WTO dispute settlement. Through intensive discussions, the sharing of ideas, and a spirit of collaborations, we are committed to significantly contributing to the discourse of DSU 2.0, ensuring a robust, efficient, and equitable dispute settlement mechanism for all the WTO members. This conference is divided into 3 panel sessions, 2 plenary sessions, and 9 technical sessions, where leading experts in international trade law will guide discussions on crucial aspects of the DSU reform process. These sessions will be led by distinguished experts like Mr. Ujjal Singh Bhatia, Professor Peter Vanden Bosch, Professor Werner Zudok, Mr. Jayan Das Gupta, Mr. Atul Kaushik, Professor James, Professor Abhijit Das, Professor Sheila Rai, Professor Leila Chokron, Professor Sai Ramani, Ms. Stuti Toshi, Ms. Tanvi Praveen, Ms. Tista Lehri, and Ms. Divya Shuri and Anvesha Pal. I wish to inform you that we have received a huge response from the students, researchers, and professionals across the country to present the paper in the conference. To ensure the quality, we followed a very rigorous process of abstract selection and selected 60 papers for the presentations, which merely constitutes 1/3 of the total number of abstract received. Once again, I extend my heartfelt gratitude to all the panelists who have generously accepted our invitation to participate in the vital conference. I wish all the participants the very best for enlightening and the
కాసిన పాట
productive
కోసం
conference. Thank you.
నాది వస్తుంది ఇప్పుడు ఛాన్స్ మాట్లాడు.
Thank you, Kapil, for the wonderful overview of the conference. You did make us realize the immediate need for reforming the dispute settlement system, and we are proud to be hosting a conference to further the academic discourse in this area. May I now invite our center's director, Professor P.S. Rao, who has joined us virtually to deliver the welcome address.
Thank you very much. I hope you hear me. Can you hear me now?
Yes, sir.
You can hear me. Thank you very much. First of all, I would like to welcome distinguished Vice Chancellor, Krishna Deva Rao, distinguished Registrar, Vijayalata Reddy, Madam, and distinguished panelists of this particular session, as well as various panelists for the various other sessions. I welcome you all. Your participation in this particular on this important subject is extremely educative as well as timely. This is a body, WTO is a body which has earned its reputation not only because it has some of the widest and most clear principles by which international trade and business will have to be conducted, but also a system by which any dispute concerning interpretation and application of these principles, if a subject of controversy or a dispute, can be settled without too much of hassle in terms of jurisdictional issues, in terms of other consent and other consent-based jurisdiction, which normally is the case in most of the international law matters. The negative consensus that has been developed as a principle for negating overriding the panel decisions is a very important step in the direction, and that is now perhaps one of the reasons why there is certain difficulty for some of the countries which consider themselves to be the path breakers rather than path followers to find it difficult to follow. And because the rule-based system which WTO has adopted, thanks to the appellate body's own procedures, would normally not allow a decision taken by appellate body based on facts and other principles that they have identified as relevant for the particular issue. Leave alone those controversies which have been plaguing the system. The multilateralism itself has been under attack for a long time, and so-called pluralism and let's say make any country great again is a call for a certain isolationism and certain particular special needs of the particular group as opposed to the international community in general. I think the rule of law has to be the basis by which international relations have to be conducted, particularly the trade and business has to be conducted. And if multilateralism is not encouraged and certain obedience is not given to general principles of law as recognized by the practice of states as well as the courts, then the rule of law is at stake and we will have a lot of difficulty. Currently, we have tremendous amount of crises that are impacting the world economy, not only in terms of supply chains, but also in terms of who should supply to whom what, under what circumstances is becoming a very important issue. And under the circumstances, we must go back to the roots of the trade law, as it were, to ensure that some of these basic principles by which the WTO has been established are re-emphasized and pronounced. We must pronounce our loyalty to these things if we want to bring back certain order in terms of the trade and other matters, particularly artificial intelligence, cyber security, and many other things are now impacting also. Under the circumstances, rule of law cannot be dispensed with any sense of individual preferences. A community sense is necessary, and commitment to common goals is necessary, and a common interests are, should guide us in this process. And this 2 day conference will certainly help us identify with the kind of expertise we've now been able to attract for this particular meeting, should be able to identify some of the most important proposals for reform and their chances of success in the next few months and hopefully not years to come. Under the circumstances, I welcome each one of you, the distinguished members of the panel, and then and also those who are participating as member in the conference itself. I welcome all of you. I want to close this welcome address only with one or two sentences of gratitude I want to express to Professor Jeevan Reddy, Justice Jeevan Reddy. Justice Jeevan Reddy, perhaps most of you don't know, is one of the most socially conscious, just social justice conscious judge I've ever seen and worked with. And I have a very close collaboration with him, and his influence both in the Supreme Court through his judgments as well as his personal rectitude is such that we have been extremely proud to host this center in his name, and he has been our patron. And not only patron, he has been boarding, guiding, and otherwise making sure that we are constantly on our track to ensure proper issues are discussed, disseminated, and technical training also been provided to various students under different sub-subject matters. Dr. Justice Jeevan Reddy's contribution is enormous through his career, and through the center, he has made sure that his name will tag on to any development that takes place on behalf of India, and where India is going to be a player. Jeevan Reddy Center will be there, and we want to be sure that the center will play an important role in the years to come. Thanks to his inspiration, we will continue to work to the best of our ability to ensure that the center makes a mark of its own as an Indian institution, of not only Indian institution but an international institution. And all of you are participating today have attested to the importance of helping such centers around the world, particularly the one we have here in Hyderabad. I wish you all success and great contribution to expected, and we look forward to your participation with success. And I wish the conference all success. May God bless you all. Thank you very much.
Thank you, Professor Rao. Now I'm delighted to welcome our Vice Chancellor, Professor Sri Krishna Deva Rao, to deliver the presidential advice. Yes. Now I would like to invite Mr. Preetham Banerjee, Head of Center for WTO Studies, to deliver the address.
Thank you. I hope I'm audible, and a very good morning to everyone. I would like to first thank Professor Kapil Sharma for reaching out to us and proposing this collaboration. It's an absolute privilege for the center to be participating, and I apologize for my lack of physical presence in Hyderabad today. But I'm glad to acknowledge that my colleague, Professor James Nidumpara, who heads the sister organization, Center for Trade and International Law, CTIL, is very much there flying the flag for our combined centers. I would like to acknowledge Professor P.S. Rao, Director, Nalsar University of Law, Professor Sri Krishna Deva Rao, Honorable Vice Chancellor. Also acknowledge the presence of Ambassador Udal Singh Bhatia, uh, Professor Werner Zadok, and Professor Reddy, Registrar at Nalsar University. Uh, Welcome addresses and the remarks that we have already heard kind of puts the perspective on what we look forward to in this conference. And in some ways, I'm a little bit of an odd person out because I'm an economist amidst uh, some very esteemed lawyers. So I'll restrict my remarks and my expectations uh, of this conference from a slightly different perspectives. Uh, the larger point that I would like to make here is that the question that comes to my mind when I look at the crisis besetting the dispute settlement system of the WTO is that whether this is a geostrategic choice to create policy space for aggressive industrial policy, like that we have seen in the United States, which they seem to have succeeded in doing with using the security exception for imposition of tariffs for steel, or is it a genuine rethink on the structure and administration and the powers of the WTO settlement system, which seems to be the official narrative that is being put forward? I think the conference needs to deliberate on both these aspects because I think both of them are perhaps equally important depending on where you look at it from. But there's a third perspective as well. The question that has often come to my mind is that whether this crisis is a withdrawal from the brief interlude where there was a genuine attempt to create a rules based system post the end of the Cold War. And in that sense, it follows a pattern. And we economists like to talk about business cycles and patterns that we see. So perhaps I'm overthinking this. But there seems to be a cyclical pattern in politics and history as well. We had a League of Nations post the First World War, and it tried to establish a rules based system. It went some distance, and then politics overtook it. We had the Bretton Woods system post the Second World War, of which GATT was definitely a part, and that went some system, and one would argue that had quite a few successes of its own. Then, of course, the Rugia round started before the Cold War officially ended, but the WTO, many would argue, was possible because of the political economy of a post-Cold War, time. And the very ambitious dispute settlement mechanism that came out in the WTO was perhaps a outcome of that political scenario that we had, the enabling political environment that we had at that time. If that is the if that's the cyclical pattern, is that's the the quote unquote business cycle of policy that we are seeing, then perhaps there is some case for hope as well. For just like in the case of business cycles, the productive investments and learnings made in earlier periods of boom emerge as a critical resource for the new growth in the next cycle. So we have seen that the investments made in the earlier periods of history are often important in the design of the next set of reforms. So Bretton Woods and the UN system owe much to the League of Nations, and earlier institutions like the GATT was part of that, and obviously the WTO emerged from GATT. The question, therefore, before the esteemed participants of this conference is to deliberate on the pathway and indeed the distance we need to go, and whether this would mean new beginnings or reform of an old system. And these are not easy questions to answer, and I am extremely encouraged to, from the words of Professor Kapil Sharma in terms of the level of participation and interest that we have, and of course, the galaxy of legal academics and luminaries we have to guide us in that discussion. Once again, I would like to end by expressing my deepest gratitude for considering the Center for WTO Studies as a partner for this endeavor, and my heartfelt gratitude to Professor Kapil Sharma, for his constant efforts to make this partnership work. With those words, thank you once again, and very best of luck to all the participants of the conference. Thank you.
Thank you, Preetham sir. And we once again extend our gratitude to Center for W2 Studies for collaborating with our center. Now, may I request our Vice Chancellor, Professor Sri Krishna Deva Rao, to deliver the presidential address.
Honorable Justice B.P. Jeevan Reddy Garu, who inspired Nalsar Law University, Hyderabad, to establish the Center for International Trade and Business, Ambassador Ujjal Singh Bhatia, former member and chair of affiliate body, Professor Werner Zudok, former director, WTO Affiliate Body Secretariat, Dr. Preetham Banerjee, Head Center for WTO Studies, uh, who joined just now, addressed us through online, Professor P.S. Rao.
No, now I don't have to. Earlier I was thinking that Jeevan Reddy was going to be around. Is Jeevan Reddy there now?
Yeah, just, yeah,
Okay.
I think we will. And my colleague, Vijulata, distinguished invitees, students, I'm delighted to welcome all of you to this international conference on crisis and solution to dispute settlement system under WTO. I appreciate and congratulate my colleagues in the Center for International Trade and Business for taking this initiative and jointly organizing this conference with Center for WTO Studies, India Institute of Foreign Trade, New Delhi. I think Preetham Banerjee has underscored the importance of this conference. And we know the very fact that the need for reform of WTO dispute settlement system is being discussed in this conference with such honored guests and esteemed colleagues that really signifies how pertinent is to engage in an academic discourse on such a pertinent and relevant theme. It's very important for the India, which is really emerging as an important destination, which also is playing a very proactive role in the United Nations, peace, trade, development, and business. I think that's what we have seen. The first phase of globalization, second phase of globalization, and now the third, more rigorous, intensive debates and discussions must happen. I think that's what I support and agree with Professor Preetham Banerjee. And I also say economists, lawyers, all of us have to come together. Trade law is a multidisciplinary area which requires several of us proactively engaging and changing the face of the future WTO. And that's what the dream and the inspiration behind this conference. This conference is very timely as the appellate body has been defunct since 2019. Just now in the interaction, Justice B.P. Jeevan Reddy was also highlighting this. And we know who are the countries which also as part of this defunct WTO system, but we have to take both this, how do we move forward? That's what the dispute resolution is about. In India, if you look at, all of us aware, since the amendment to the Civil Procedure Code in 2001-2002 onwards, and then the mediation, which has become as an important aspect with the 2023, the Mediation Act, dispute resolution has become very important. I tell all my colleagues in the personal life, professional life, particularly in the trade and development, dispute resolution is a very effective system. I was asked one of my colleagues to watch this movie Oslo. I think I would recommend all of you to look at the Oslo film, which clearly explains how the international negotiation between Palestine and Israel, and then how they have moved. The minute of meeting together on a table itself is, I think Professor P.S. Rao, who has a vast experience in the international negotiation, former member of the International Law Commission, is aware of this. So therefore, I would consider this is a renewed effort for improving global trade after the pandemic that demonstrates the importance and relevance to address the problem in dispute settlement system. We have been hearing that the agreement that lays down the procedural rules for WTO dispute settlement system, particularly dispute settlement understanding, is considered the crown jewel of the WTO. It has got the right title given the effort and resources spent for negotiating dispute settlement understanding in the Uruguay round. It should be noted that the lessons learned in resolving trade disputes from 1947 with the signing of the GATT and the establishment of World Trade Organization 1994 were all incorporated in the DSU. Therefore, the DSU established a standing appellate body, introduced negative consensus as the decision-making norms at different stages of the DSS. Despite of all these, the DSU has achieved and contributed to the strengthening of a rule-based dispute settlement system. It needs to be reformed in order to revitalize the dispute settlement system. In this regard, I think this conference is a right step in that direction. The center, under the able guidance and the leadership of Professor P.S. Rao, has called the experts in the field of international trade law for this conference. I have welcome Ambassador Ujjwal Singh Bhatia once again, former chairperson of the appellate body, Professor Werner Zudok, former director of the appellate body secretariat, Professor Peter Van Deen Bost, former chairperson of the appellate body, Professor Preetam Banerjee, Professor James Nedpara from the IAFT, Atul Kaushik, former additional secretary to Government of India, Jayan Das Gupta, former ambassador of India to the WTO, Professor Leela Chokon, Professor and Director of the University of Portsmouth, Professor Abhijit Das, former head of the Center for WTO Studies, Professor Sheila Rai, Director, National Law University, Orissa, Center for International Trade Law, Professor Shailaja Singh, Professor at the Center for WTO Studies, Ramani from the South Asian University, and Mrs. R.V. Anuradha, partner at Claris Law Associates. Apart from getting insights from these people who are working closely in reviewing the appellate body, this conference has also garnered sufficient attention from all the student community. I think I must appreciate this. The 9 technical sessions will ensure that academic discussions are generated on the team. To chair these sessions, many practitioners and professors have graciously accepted our invitation. This is the 3rd event of the Center for International Trade and Business Law, supported by Justice B.P. Jeevan Reddy, and glad to see enthusiastic participation from all of you. I request you all to actively engage with the panel and chairs, and also share your ideas and collaborate with each other during the conference. We are grateful to the support extended by the Center for WTO Studies, IAFT Delhi, and I thank them for collaborating with us for this conference. Let me extend my special thanks to Professor Preetam Banerjee, the head of the center. I also appreciate the efforts of our center members, Director Professor P.S. Rao, Dr. Rosmi Joan, Dr. Kapil Sharma, Ilakya, Aditya Tripathi, and the entire student team of this center for their efforts in organizing this conference. I once again thank all the dignitaries on the dais and distinguished participants, and wish the organizing committee and wish the conference a successful conference. I hope all of you have a time to enjoy Nalsar Law University and also explore culturally rich Hyderabad city. Thank you, and welcome you all once again to this conference.
Thank you, sir, for delivering the address and also for constantly supporting us and for being instrumental in bringing this conference to fruition. It is now my honor to introduce our esteemed chief guest, Mr. Ujjwal Singh Bhatia. He was appointed as the appellate body member in November 2011, and he served in that position until March 2020. He also served as the chairperson of appellate body in 2017 and 2018. He started his career as an Indian Administrative Service in 1974, and he worked in various capacities in Odisha as well as with the central government in New Delhi. He also served in the Ministry of Commerce and in the Ministry of Information and Broadcasting, and he was instrumental in negotiating key treaties for India. So without any further ado, may I now invite Mr. Bhatia to deliver the keynote address.
Thank you. I'm delighted to be here at this conference. I would like to begin first by complimenting your distinguished Vice Chancellor, Professor Sri Krishna Deva Rao, and Professor Srinivasa Rao, who is the director of the Justice Jeevan Reddy Center. Both of them very eminent jurists. They have, they have imparted a sense of quality and excellence to Nalsar, allowing it to emerge as not only one of the premier legal centers in India, but in this entire Asian region. I think it's very important to place Nalsar in the regional and global context as a center of excellence. I would also like to acknowledge the distinguished guest who could not be here with us physically today, uh, Professor Preetam Banerjee, Professor Srinivas Rao, and my dear friend, Professor Peter van den Bosch. I wish you were able to join us today. I was very much interested in the remarks that Preetam made today and the collaboration between Nalsar and the Center for WTO Studies, because both of these institutions, apart from being independently centers of excellence, have also a synergy in the sense that they work closely with the government of India to look at real problems and real solutions. So the kind of research that goes on in these centers is synergistic between the two of them. And I hope that this partnership will continue and will prosper. I particularly wished that Professor Srinivas Rao would be with us here today physically, but at least we have the consolation of seeing him online. He is one of the most eminent jurists of India, has been involved with the International Law Commission, and the work that he is doing today in the center, which is dedicated to Justice Jeevan Reddy, is something which I think can only elicit admiration and respect. Thank you, sir. About Peter van den Bosch, I will not say too much because he is easily embarrassed. Let suffice to say that I have learned enormous amount of things from him, not only law, but to be a good human being. And he is easily one of the most distinguished international law experts in the world. And I think we are all honored and privileged to have him with us. This conference is trying to understand the crisis of the WTO's dispute settlement system. For countries like India, the rules-based global trading system is a valuable public good, and it is important that we are clear about the reasons for its crisis so that we can contribute to its resolution. Since the inception of the WTO, its dispute settlement system has set it apart from other multilateral organizations. The dispute settlement system, with its compulsory jurisdiction, appellate review, clear timeframes for proceedings, and its surveillance and monitoring of compliance, is unique among international state-to-state dispute resolution mechanisms. It has also been the most often used system. Since 1995, WTO members have brought more than 600 new disputes to the dispute settlement system. As on 1st October 2021, a total of 235 panel reports and 148 appellate body reports have been adopted by the WTO's dispute settlement body. This level of activity is unmatched by any other comparable dispute resolution mechanism. The crisis of the dispute settlement system was long in coming, but in hindsight, perhaps inevitable. The dispute settlement system was created at a time when the world's economy, trade, were dominated by a single superpower and a single philosophy, aptly summarized by the Washington Consensus. The United States had enormous confidence in the permanence of its power and interests, and was thus willing to surrender sovereignty in resolving trade disputes to an international body. But since the WTO was created, the world has changed dramatically, and we are now in a new era of uncertainty and multipolarity, with many players and different priorities jostling for position. Developments like the rise of China and other emerging countries like India, and the consequential changes in geopolitics, the heightened urgency of climate change, the increased perception of global risk brought up by the COVID pandemic, the deepening digital transformation, all these have made the world a very different place. The United States has now turned inwards, and its domestic politics makes it more sensitive about surrendering its sovereignty to international courts. During the over quarter century of its existence, the dispute settlement system has dealt with a large number of politically sensitive issues where it has had to examine the legality under WTO law of several national laws and measures in areas like environment protection, public morals, public health, trade remedies, and national security. Several of its rulings in these areas have elicited high praise and have been widely cited. But at the same time, some rulings have also been sharply criticized. The appellate body in particular has been variously charged with judicial overreach, making law, and disturbing the tightly negotiated balance between rights and obligations in covered agreements. These criticisms reflect a reality with which we must deal. While the functioning of the dispute settlement system has been viewed positively by the vast majority of members, a small number of members cannot accept the changed dynamics under which the adjudicative process functions and would like to review the fundamentals of the dispute settlement understanding. This review possibly includes principles which are foundational in the DSU, like the binding nature of dispute settlement and the provision for appellate review. It is important to bear in mind that the dark cloud of uncertainty over the dispute settlement system is inextricably linked to the crisis of the WTO itself. One cannot be resolved without the other. The mismatch between a very active dispute settlement system and an almost paralyzed legislative function constitutes the basic conundrum for the organization. Even if a workable compromise is reached on the dispute settlement year, by the year-end deadline, the dispute settlement system will inevitably be accused of making law in its interpretations when it seeks to resolve present-day disputes on the basis of rules negotiated over a quarter century back. Unfortunately, however, the WTO members are nowhere near a common understanding of what the WTO of the future should look like and how the rules should be changed to accommodate new global challenges like climate change, pandemics, food security, and the increasing digital divide. And yet, the resolution of the WTO's crisis is vital if the world is to navigate this period of uncertainty. Global challenges require globally coordinated responses. That is the essence of the rationale for multilateralism. The national interest of all countries is best pursued by international cooperation in addressing global challenges. It is this understanding that must guide our approaches to resolving this crisis. Thank you very much.
Thank you, sir, for giving your insights into the theme of the conference. Next, we have another distinguished guest, Professor Werner Zudok, former director of the WTO Appellate Body Secretariat from 2006 to 2020. He is currently the Director of the Knowledge and Information Management, Academic Outreach, and WTO Chair Program Division of the WTO. So I would like to invite Professor Werner Zudok to address the gathering.
Thank you very much. Let me start by first thank Professor Kapil Sharma, Professor Srinivasa Rao, distinguished ILC member, Professor Preeta Banerjee, Professor Sri Krishna Deva Rao, Professor Vidyulata Reddy, and other faculty members, and of course all of you, the students of this law school, and all the organizers of the Jeevan Reddy Center for International Trade and Business Law at Nalsar, and the authorities represented here today for inviting me to this distinguished conference on a very important topic to the WTO and beyond. My special thanks go also to my friend, former appellate body member Ujjwal Singh Bhatia, Peter van den Bosche, and the WTO chairholder from the Center for Trade and Investment Law and the Indian Institute for Foreign Trade, James Nedumpara, and all other distinguished academics and representatives of legal professions represented today. Ladies and gentlemen, the world and thus the WTO are witnessing an era of deglobalization which changes the parameters for WTO dispute settlement and its reform. This conference is of key importance because the system of the multilateral trading system depends crucially on a functioning dispute settlement mechanism at the WTO and maybe also in other fora. These other fora may also be relevant, but for the WTO, at the crossroads of remaining relevant, the lack of a fully functioning dispute settlement system affects a lifeline. Without a binding enforcement system, the covered agreements do not remain credible international commitments. This undermines the entire WTO's attractiveness as a forum for negotiations of new obligations and its relevance, its continued relevance for the WTO membership at large. The basic consensus about the governing principles that underlied the GATT 1947, which was a much smaller club of essentially like-minded countries, is gone. We're living in a multipolar world with increasing diversity of interests and basic values that are not universally shared among all of the universal WTO membership of currently, now since the last ministerial conference, 166 states and separate customs territories. There is no basic consensus anymore about the fundamentals of the multilateral governance and the world trading system in particular. This has repercussions on the dispute settlement system, in particular the degree of binding nature and the lack of coherence of views on the features that should characterize an international dispute settlement system and what it should achieve in resolving disputes. Increasing interlinkages between trade rules and practices and other policy areas have repercussions on how a dispute settlement system should function, both procedurally and substantively, as tight compartmentalization of legal instruments and trade law, as opposed to international law on investment, industrial policy, sustainability, climate change, as my preceding speaker has mentioned, preparedness for pandemics, digitalization, technology transfer, inclusiveness, and poverty eradication, geostrategic concerns dominating trade relations, just to name a few, may neither be possible nor desirable. Despite the backlash against globalization, we still live in a globalized world order, though, where trade rules do not operate in isolation from rules and practices governing those other areas such as investment, digitalization, sustainability, and climate change measures. Ignoring this may lead to members facing conflicting requirements and lack of coherence in policymaking by all relevant stakeholders. Therefore, not strictly trade-related rules in those areas should be taken into account when interpreting WTO obligations and exceptions or applying the trade rules in a manner that fosters coherence with other multilateral obligations, such that the potential for sovereign states to face conflicting obligations is curtailed. At the same time, the circumscribed mandate of the WTO remains to be respected. Let me conclude by strongly encouraging India to play a more active role in vital areas of the WTO's reform and in shaping the future agenda of the WTO and other international institutions. Rigid insistence on strict multilateralism and unconditional FN in shaping the WTO negotiating agenda is probably ultimately also not in the interest of India. Simply rejecting joint initiatives proposed by growing numbers of other WTO members is not a forward-looking agenda that will allow India to propagate topics of its genuine own interest in multilateral solutions to public stockholding, digital transformation, crossing the digital divide, reconciling sustainability and combating climate change, while fully respecting developmental and industrial policy agendas, and ultimately a more inclusive world economic system geared towards poverty eradication in all layers of society. This conference will no doubt be a significant contribution to shaping India's approaches to re-establishing a functioning WTO dispute settlement system, as well as viable temporary alternatives. Thank you very much for your attention.
Thank you, Professor Werner Zurek, for bringing these ideas to the table, unlike your airline, which who could not bring your luggage. May I now request Professor K. Vidyulata Reddy to deliver the vote of thanks?
So, distinguished guests, it's my honor to propose the vote of thanks on behalf of Nalsar University of Law. I would like to first thank the Center for WTO Studies, IAFT, for collaborating with Nalsar University of Law in organizing this international conference, the two-day conference on crisis and solution to dispute settlement system, and the effort mainly of our team, Kapil Sharma, Rosmi, and Elukia, who worked together very hard, Aditya Tripathi and Rajesh Kapoor collaborating with them. They worked very hard to make this conference and bring these dignitaries to here for this conference, and along with all other enthusiastic participants from the student community as well. So I congratulate them on this. And I now thank our Professor P.S. Rao, sir, Director, Justice B.P. Jeevan Reddy Center for International Trade and Business Law. He has given the tone for the conference by suggesting how rule of law as a basis for dispute settlement and multilateralism, should it take over the general rule of law, and whether the changed scenario in the international arena, more especially with the AI and cybersecurity, whether the existing regime would suffice, or should we deliberate on the new era that needs to be emerged in this regime. So I think the conference will take his words more seriously to discuss that further. And I thank Professor Preetham Banerjee from the WTO Studies Center from IIFT, who was also suggesting to critically explore the rule-based system of WTO and whether the GATT to WTO and to the present regime, what is the role that the WTO is playing and should be playing. And I thank our Professor Sri Krishna Deva Rao, Vice Chancellor, Nalsar University of Law, and for suggesting the reforms. The conference should be able to suggest reforms that should be taking place, and he is more precise and clearly pointing the direction to the conference about how the Indian stand should be and what the reforms should why the crisis has actually been there, and the kind of defunct nature, in a way we could call it, for the last 4 or 5 years, and how we should come over this crisis. And I would like to thank our keynote speaker, Ujjal Singh Bhatia, the former member and chair of the WTO appellate body. Thank you, sir, for coming all over to Nalsar to deliver the keynote address. And what more pleasure than to hear from the person heading the WTO dispute settlement body for quite some time. Your experience and your vision and guidance would definitely take this conference to a very useful level to the university and to the students, and more especially to the Indian strand as it is. And very interestingly, you have given the major reasons for the crisis. I think the mostly surrendering sovereignty by some of the states, and the rules of the WTO appellate body being laid down 25 years back, and more especially criticism in some environment related cases. We have seen lot of academic writings in this area where people have went on criticizing, saying whether WTO's decisions are laying a kind of hierarchy within the treaties, whether trade law agreements are given supremacy over other agreements is a common conflicting points. And we have seen how even inclusion of one savings clause in Cartagena Protocol took 2-3 years for debates and negotiations. So I think your direction in this, your crisis points, which you have pointed out, the three major crisis points would be detailedly deliberated in the next 2 years, and I think we would be able to come out with some positive outcome and some suggestions for this. Thank you very much. And I now thank Professor Werner Jodau, former Director, WTO Appellate Body Secretariat. Thank you, sir, for coming all over to deliver this lecture. And you have clearly stated how the last ministerial conference couldn't come to a solution on how the DSU should work and how to resolve this. And more especially, we need to look at more procedural and substantive rules of law so that we could have, and your guidance about and your suggestion that India should play a more strategic role would be very well taken. And it's more happy to hear from you that India should take such a stand. And I hope institutions like Nalsar and IAFT has to take the lead in this. And we are very happy that under this conference will be the beginning of this deliberation and would continue, this center would continue to perform even better and better in days to come. And I would like to more specially thank our Justice BP Jeevan Reddy Garu, under whose name this center is headed, for his generous donation and for the guidance and his absolute modesty about requesting not to be keeping his name for the center and not to be given any kind of special honor to him. So, but we thank you very much, sir. Your guidance will always help this institution to take it forward. And I thank all other distinguished guests who have come over and are present here, and Professor Peter and all other ambassadors and ministry members. Thank you, sir. Thank you, all of you. And I welcome my old faculty, friends and colleagues, Sai Ramani and all the friends. Thank you all. Thank you all.
Thank you, ma'am. And I would also like to add your name to the list that the center should be grateful for, be it the fact that you called us to your office to ask what our requirements are for the conference and for promptly releasing the funds. We want to express our gratitude to you as well. Thank you, ma'am. Once again, I welcome you all to Nalsar University of Law. We hope you enjoy the conference. So stay tuned for our first panel discussion, which will begin shortly. But before that, I request each and every one of you here to assemble for a group photograph right outside this building. Right. So after that, we can proceed for tea. So very quickly, I want everybody to assemble for the group photograph. Thank you, everyone.
Thank you.
Yes, sir. So please follow the directions of the organizing committee members. They will take you to the location.
Hello, ma'am, I audible? Sheila ma'am, Shelja ma'am. No, no, no.
Yes, Kapil, you're audible.
Ma'am will be starting a session in 5 minutes.
Hello everyone. I request all of you to take your seats. We will be starting in a while. I request all of you to keep your mobile phones in silent mode. Thank you. Good morning, everyone. I'm Dr. Rosmi John, Associate Professor of Law and the Faculty Coordinator of Justice BP Jeevan Reddy Center for International Trade and Business Laws. It gives me immense pleasure and privilege to welcome you all to the International Conference on Crisis and Solutions to Dispute Settlement System under WTO. Now it's time for us to start with the first panel discussion. The first panel discussion is titled as From Crisis to Consensus, Innovating Solutions for DSU Revitalization. Over the past 2 years, the absence of the appellate body has undermined the WTO dispute settlement, where first instance panel report can be appealed into the void due to a non-operational appellate body. Faced with the blockage of the adjudication system, however, several members have shown an unprecedented sense of innovation, both to manage the dispute processes differently and to improve governance mechanisms in committees preceding the dispute settlement process. This sudden openness to alternative settlement models is of considerable scientific interest, with real implications for global trade policy in the years to come. This conference is part of the same search for alternative models and new approaches to revitalize the DSS, which is also reflected in the WTO members' commitment to a fully and well-functioning dispute settlement system accessible to all members by 2024, as stated in the Geneva Ministerial Declaration of June 2022. This conference brings together international experts who will explore the new avenues for resolving disputes. We have convened experts who are the academics, practitioners, diplomats, as well as former trade negotiators and appellate body members of the World Trade Organization. It's time to do the crowdsourcing, the intellectual labor that is required for lasting and successful reforms. Let's see who all are there on the panel today. We have Mr. Ujjal Singh Bhatia, who is the former member and chair of the appellate body. He is currently an honorary professor at NLU Delhi, and he was selected twice as the chairman of the appellate body, and he also served as India's ambassador and permanent representative to the WTO between 2004 and 2010. And we have Professor Peter van den Bosch. He is also the former member and chair of the appellate body, and he is currently the Director of Studies and Professor of International Economic Law at the World Trade Institute of the University of Bern and the President of the Society of International Economic Law. We have Professor Werner Dock, who is the former Director of the WTO Appellate Body Secretariat, and he is currently the Director of the Knowledge and Information Management, Academic Outreach, and WTO Chairs Program Division of the WTO. In 2008, he chaired the WTO Joint Advisory Committee to the Director General. He has been a lecturer and visiting professor at Vienna Economic University, the universities of St. Gallen, Zurich, Barcelona, Seoul, and Shanghai, and the Geneva Graduate Institute. From 1987 to 1989, he worked for the governmental and non-governmental development aid organizations in Austria and Latin America. We have Professor James Nedumbara, who is professor and head of CTIL, IAFT, Ministry of Commerce and Industry, Government of India, and he advises government on international trade, investment, and dispute settlement matters. Professor James is a founding faculty member at Jindal Global Law School, and I'm really proud to be a student of him. And he's also worked at the United Nations Conference on Trade and Development India program, and he is currently the India chair of the WTO Chairs program. And we have Mr. Adul Kaushik, Additional Secretary, retired of Government of India, and during his period, he conducted research and workshops for the members of parliament. His areas of work while in service with the Government of India included export promotion, bilateral and multilateral trade policy, petroleum, climate change, and justice. And he was the India's negotiator for international trade and climate change, and India's lawyer in the permanent mission of India to the World Trade Organization in Geneva. He has also served on the board of directors of public sector undertakings, and he has delivered trade and development projects in Africa and for the African and the South Asian trade negotiators in Geneva and Indo-US Triangular Development Partnership Program in New Delhi. He also served as a consultant to UNCTAD, OECD, IST, and GSZ, among the others. He also conducts training programs in National Judicial Academy, Indian Institute of Foreign Trade, and the Institute of Secretariat Training and Management of the Government of India, and so on. We have Professor Sheila Rai, who is the professor and director of the Center for International Trade Law at the National Law University, Odisha. He is a very well-known academic in the area of international trade law. She is trained from the National Law School of India University, Bangalore, and she has written extensively, various books and publications in the area of international trade law, and she has experience with various national law schools in the country. And we also have Professor Shailja Singh. She is a legal consultant and associate professor at Center for Trade and Investment Laws, IFT, Ministry of Trade and Commerce, Government of India. She is a lawyer and trade policy advisor with over a decade of experience in international economic law. And she is also part of the Government of India's trade negotiation policy and dispute resolution. He also leads a team of legal research fellows at the Center, IAFT, Government of India. Now it's time for us to start to hear from our experts. Let me invite Mr. Ujjal Singh Bhatia, former member and chair of the Appellate Body Secretariat, to share his views on this fundamental question, what to expect from the ongoing reforms. Over to you, sir.
Thank you very much, Rosmi, for this introduction. We have, I think, 1.5 hours, and we have 7 speakers, so I think it's important that we are brief in our presentations. And that's a pretty easy thing to do, given the topic that I have, what to expect from DSU reform. I will begin with my conclusion. And my conclusion is that it's a very difficult question to answer at this stage. In the 12th Ministerial Conference in 22, the ministers agreed to conduct discussions, and I quote, with the view to having a fully and well-functioning dispute settlement system accessible to all members by 2024, end of quote. And this decision was broadly reiterated in MC13, which concluded last month. WTO members have been engaged since February 2023 in an intensive process of informal, small, and larger group meetings referred to as the Molina process. The process has now been derailed because Mr. Molina has been withdrawn by the Guatemalan government. Now, however, before he moved away, Mr. Molina presented to the DSB in February 2024, just before the ministerial conference, the 7th version of the draft text, based on the meetings and discussions that have taken place over the last 1 year. This text does not address the main issue for which is the most proximate issue for the crisis, which is the appeal or review mechanism. Now, what does the February text say? It has made, firstly, some very interesting proposals to provide more substance to alternative dispute resolution procedures and arbitration pursuant to Article 5, 24(2) for the former and Article 25 for the latter, which is arbitration. Similarly, for panel proceedings, it makes a series of proposals based on past experience regarding the establishment of panels, their composition, and some interesting ideas to streamline the panel process. In principle, the ideas discussed to streamline the process are welcome, but I suspect once the consultations open up in a formal way, there will be other views expressed beyond what is captured in the text. For instance, there are proposals for word limits for written submissions and time limits for oral submissions. These will obviously require deeper discussion. The appellate body tried to impose or tried to elicit views of the members regarding such submissions, and we had to frankly close that file because there was not much agreement on that score. More controversial will be the panel's proposed categorization of disputes into complex and extraordinarily complex, and the proposal to focus on what is necessary to resolve the dispute, as parties may have very different views in this regard on various claims. Now, it has a section on guidelines for adjudicators, and I will not talk about that because Peter is going to be talking about that. I will just, there are basically three issues which it discusses. The first is about treaty interpretation. The second is about focusing on what is necessary to resolve the dispute. And the third is that there will be no precedential value of past reports. Let me just make a very brief comment on the last aspect, which is the precedential value. It is nobody's case that past decisions will have a dispositive effect, but the requirement of security and predictability that is imposed on adjudicators in the DSU requires similar disputes to be dealt with in a similar manner, unless the facts of the current dispute are so different that they require a different treatment. The proposal has an interesting idea to establish an advisory working group to review decisions and interpretations of panels. I think in principle, that is an idea which we should welcome, because the negative consensus rule that the DSB works under has given enormous authority to panels and the appellate body, and it is almost impossible de facto to reverse any recommendations which have been made by the panels or the appellate body. Now, panels or the appellate body are not infallible. And therefore, if, for instance, the members feel that a particular interpretation should be different from the ones which the adjudicators have decided, I think there needs to be a procedure for discussing these various views and coming to a conclusion. But the practical problem would be what happens then? Because under the text of this report, the recommendations of the advisory working group are to be by consensus. And I, for one, will find it difficult to imagine why a party which benefited from a particular interpretation would join that consensus. And secondly, ideally, if you cross that first barrier of a consensus decision by the advisory working group, you would then ideally go to an authoritative interpretation under Article 9.2 of the WTO agreement. And there again, it would require, in de facto terms, of course, consensus. So there are many issues that will come up when there are formal discussions on this issue. So let me summarize. Here are the key issues which I believe are important here. First, the proximate cause of the crisis in the DSS is paralysis of the appellate body. The informal discussions have not discussed that issue yet. For the last about 5 odd years, more than 120 members have been proposing the beginning of the selection process for the appellate body in successive DSP meetings. This has been consistently vetoed by the United States. Second, the process so far, though very active, has been informal. At some stage, it will have to be formalized through a DSP-driven formal negotiation. It is not clear how and when that will happen. And thirdly, lastly, the deadline for the outcome as of now is December 2024. With the US elections being held in November, it is difficult to see how a final outcome can be reached by that time. So in brief, let me go back to my first sentence. It is difficult to forecast what can be expected from the DSU reform process at this stage. Thank you.
We should actually see the first question, that is what to expect from the ongoing reforms. Now, let me take the privilege of inviting Professor Peter van den Bosch, former member and chair of the Appellate Body Secretariat. Professor Bosch will be helping us to understand the question, how the guidelines for adjudicators will change the course of the dispute settlement system. Over to you, Professor Bosch.
Thank you very much. Can I be clearly heard? Hello?
Yes, sir, we can hear you.
Thank you. Let me start by thanking the organizers. The invitation to participate in this conference, this important conference, this conference on a very important topic, as was already highlighted by previous speakers. This invitation to participate is highly appreciated. I regret not being able to participate in person. The reason for that is partly dispute settlement related, because I will be active as a panelist in a pending dispute the whole of next week. It's always a pleasure to be on a panel with dear friends, Ujjal, Werner, James, Celia. It's great to see you. Now, Ujjal has made, as he often did in the past, has made my life much easier by introducing what's happening in the context of, or what did not happen in the context of the ongoing, and I would say still ongoing, Molina process. Marco Tullio Molina is gone, unfortunately, but I think the process will continue, has to continue, and that's also what the ministers decided at MC13. But as Ujjal pointed out, it's very, very true that once the negotiations on dispute settlement reform enter into a formal stage, we may see that things which are currently in the draft ministerial decision will be up for debate again. Yeah. Nevertheless, I think it is very important to pay great attention to this draft decision, because after all, 163 WTO members actively participated in this process. There were 300 plus meetings of which 100 plus are plenary meetings. Yes, it was all in an informal setting, but I think this deserves particular attention, particularly because, and that is what Marco Tullio Molina also observed when he presented the report as it stands, the text as it stands, the draft ministerial decision, reflects, and I quote Molina, the collective understanding and expectations regarding the system's operation. So, the text has 11 titles, and the conference organizers asked me to focus on one title. But before getting there, and as a way of getting there, I would like to repeat what Ujjal already said, namely that the negotiators so far have been unable to agree on the most important issue, appellate review. While this is obviously the case, nevertheless, I think that what has been agreed is to a large extent also addressing issues that have explained or that are at the basis of the appellate body crisis. And that brings me to the title of the draft decision that I was asked to talk about, namely Title 5. Title 5, which is one of the 11 titles, Title 5, which is entitled Guidelines for Adjudicators. Now, that Title 5 has 3 chapters, and Ujjal already indicated that. A title entitled Treaty Interpretation, a chapter entitled Focus on what is necessary to resolve the dispute, and a last title, entitled No Precedential Value of Past Reports. Now, referring to chapters may be a bit misleading, because actually these chapters are in fact very, very short and contain anything between 1 and 4 paragraphs. So rather than chapters, they should perhaps have talked about provisions or articles, but they call it chapters. The chapter on treaty interpretation and the chapter on what I refer to as obiter dicta, I'll explain that a bit later. These 2 chapters, on a first quick reading, state the obvious and are totally unremarkable, and I would say totally harmless. Yet, when one looks more closely, it becomes clear that these chapters reflect a significant but perhaps ill-advised effort on the part of the membership, on the part of the WTO members, to address concerns the United States has expressed. The first paragraph of the chapter on treaty interpretation, the first paragraph recalls Article 3.2 of the DSU. Article 3.2, that, as we all know, requires adjudicators to interpret the covered agreements in accordance with customary rules of interpretation of public international law. And thus, Article 31, 32, and 33 of the Vienna Convention. The first 4 lines of this paragraph state the obvious. What is interesting, however, is what is in the following 9 lines. In those other lines, so actually 4 lines state the obvious, and then we have another 9 lines. In the following 9 lines, there is no further elaboration or clarification of the general rule of interpretation set out in Article 31. The following 9 lines are all about the supplementary means of interpretation. Most of these lines are a copy-paste of the text of Article 32 of the Vienna Convention. But, and this is what bothers me, the excessive importance given to the supplementary means of interpretation, and in particular, the preparatory work of the treaty, that is the negotiating history, is a clear concession to the United States, which has often criticized the appellate body for not giving more prominence, more importance to the negotiating history of agreements, and in particular the negotiating history of agreements on trade remedies. The United States, that's very well known, wants more importance to be given to the negotiating history, and that's what this paragraph does. The problem is that there is no agreed negotiating history, no travaux préparatoires that were adopted by the parties to the negotiations. There is none. Of the WTO agreements, there is none. Those who wish to rely on the negotiating history usually rely on their own negotiating positions and papers. And the invocation of the negotiating history then often becomes shamelessly self-serving. I consider the disproportionate attention to supplementary means of interpretation in this first paragraph of chapter 1 unfortunate. Now, moving to the second paragraph of that first chapter in Title 5. Now, that chapter is on, according to its title, treaty interpretation. But the second paragraph has nothing to do with treaty interpretation. It deals with burden of proof. Or perhaps not really that either. This paragraph starts out by stating the obvious, namely that the complaining party bears the burden of establishing a prima facie case that another party has acted inconsistently with an obligation under the covered agreements. Yeah. It's only in the following sentences of that paragraph that it becomes clear why this paragraph is in the text. Because just to repeat what's in the first sentence, there was no need to put that in the draft ministerial decision. And again, this reflects an attempt by members to address a concern of the United States. Which concern? Well, the concern that WTO adjudicators, and particularly the appellate body, have found inconsistencies with obligations that are not to be found in the covered agreements. This paragraph requires adjudicators to determine first whether the complainant has made a prima facie case of the existence of the obligation it invokes. And only then, in the absence of effective refutation by the other party, the adjudicator can apply the obligation to the facts. This paragraph leaves me puzzled because do not all competent adjudicators first establish whether the obligation invoked actually exists before applying it to the facts? The second chapter of Title 5, the title on guidelines to adjudicators, is entitled, as I already said, Focus on what is necessary to resolve the dispute. Now, the first two paragraphs of this chapter primarily repeat the language that is already used that was already used in the 2019 draft General Council decision on the functioning of the appellate body, the outcome of the Walker process in 2019, and language that is also used in the multi-party interim appeal arbitration arrangement, the MPIA arrangement. So it repeats that language. And it says, adjudicators should only make findings that assist the dispute settlement body in making its recommendations and rulings, and should limit their reasoning to what is necessary to support these findings. In other words, adjudicators should avoid obiter dicta, or as the United States confusingly calls it, advisory opinions. Well, and this is a confession that I make here in the presence of another appellate body member, former appellate body member. While the appellate body on occasion probably said a bit more than was strictly needed, the reality is that WTO adjudicators and also the appellate body have been more than happy to exercise judicial economy and not rule on more than is needed. It's the complainants that bring a multitude of claims in what often could be a simpler case. Now, paragraph 3 of chapter 2 recognizes this, that the problem is more with the complainants. It recognizes this by authorizing the adjudicators to invite parties to focus the case on certain claims, or to invite them to even exclude certain claims. Mind you, such invitations are, as explicitly stated, not binding. And it remains to be seen how many complainants will voluntarily give up on some of their claims. I'm coming to the end by talking about the last chapter in Title 5. And Ujjal made already some reference to it. This chapter deals deals with the issue of precedent, and it does so in one paragraph, be it a somewhat convoluted paragraph. As is very well known, the United States has been for many years on a crusade against precedent in WTO dispute settlement, which, by the way, does not prevent the United States from invoking all the case law they agree with and insist that adjudicators should follow that case law. But setting this apart, they have been on a crusade against precedent. The paragraph in this chapter dealing with precedent starts again by stating the obvious, something that the appellate body also has said repeatedly, namely that WTO reports have no precedential value, meaning that they're not binding on in subsequent disputes. That's the obvious. But what is problematic with the rest of this paragraph is, on the one hand, what it does not say, and on the other hand, what it does say. To start with what it does not say. And this was still stated in the 2019 draft General Council decision on the functioning of the appellate body. And it's also stated in the MPIA arrangement but it's not stated here. What is not stated? Not stated that, or we're not reminded of the fact that the purpose, and Ujjal already referred to this, that the purpose of WTO dispute settlement is to bring security and predictability to the international trading system. And that therefore, it is a legitimate expectation among WTO members that the same legal issue will be decided in the same way in subsequent cases. The draft decision does not say so. And I think it's problematic that is not said. Now, what does it say? It says that each adjudicator in each case, and I quote, must develop its own interpretation of the provision at issue. An adjudicator may use in developing and explaining her or his own interpretation former previous reports, but only to the extent that he or she considers the analysis in these previous reports persuasive. I probably could live with that. But then it goes on, and this is the final sentence in this paragraph. It gives an instruction to adjudicators that they may not presume. Let me read this out as a quote. They, and I quote, may not presume that an interpretation of the covered agreements in a WTO dispute settlement report is persuasive. End of quote. This is not how international adjudication, for that matter, any adjudication, national or international, this is not how international adjudication works. Yeah? Adjudicators of today build on the hard work done and the lessons learned by previous generations of adjudicators. An adjudicator does not start afresh with the interpretation of relevant provisions each time over. Also, the parties in any case will invoke the case law that supports their arguments, and the adjudicator will therefore have to start with considering that case law. No adjudicator, except perhaps those with a dangerously big ego, will start out on a case with the presumption that his learned colleagues, adjudicators, who ruled on the interpretation of a provision before, got it wrong, and that the work needs to be done all over again. Therefore, the instruction in this last sentence is unwise, if not foolish, but it does reflect what that members are ready to do in order to accommodate concerns of the United States. We also see this in other titles on other issues of the draft decision. And that makes me fear what will eventually be done with appellate review. And with that, I conclude my comments.
Thank you, Professor Bosch, for helping us to navigate the various chapters of the guidelines and sharing your valuable insights on the potential challenges or the problems associated with the interpretation. We soon hope to welcome you to the Nalsar campus, though you could not join you physically this time. but we sincerely hope that we would be in a position to host you soon.
It will be my pleasure.
Thank you. Now it's my pleasure to welcome Professor Werner Dock, former Director, WTO Applied Body Secretariat, to share his views on how the ongoing dispute DSU review negotiations will impact the developing countries and the LDCs. Over to you, Professor.
Thank you, Rosmi. I hope we can hear this well, and also those online. I will focus on the topic on how this impacts on the DSU review negotiations from the perspective of developing countries and least developed countries. Just to set some parameters before I get to the detail of this existing draft from a developing country perspective. Obviously, the end of the binding dispute settlement system since December 2019 strongly undermines the ability of LDCs and developing countries to benefit and participate fully in a rules-based multilateral trading system. Appeals of panel reports into the void undermine the rule of law that protects less powerful developing and least developed countries because the binding effect and compliance obligations under the covered agreements are undermined. There is a need recognized in this paper for additional training in these settlement procedures of government officials of developing countries and LDCs through WTO national and regional trade policy and dispute settlement courses through the CHAIRS program, regional multilateral organizations beyond the WTO. The Chapter 9 of this new facilitators report mentions such needs for more capacity building, but again fails to spell out the detail on how this should be achieved. This includes so far only training in Article 5, alternative dispute settlement mechanisms, which are now center stage in this new draft and will be addressed by the subsequent speaker. And however, it's done currently by the Advisory Center for WTO Law in Geneva that offers country and case-specific advice at less expensive rates than usual law firms and at lower rates for WTO members that are also members of the ACWL and free of charge for LDCs. There was a proposal for another additional fund proposed by the African group that would enable developing countries to obtain legal advice at reduced rates. However, my view on this is while the Advisory Center has established itself with a mounting reputation, there is little traction for this new fund proposed by the African group because it would take years to build up the reputation and the expertise that other institutions have. I think there is also a special need for specific strategic advice to developing countries on when to settle or when to accept demands of complaining trading partners, when to negotiate also with more powerful ones, and when to litigate all the way through. What is lacking, in addition to specific advice on how to make value or put in motion findings of panel reports also when they were appealed into the void. To date, essentially only the Advisory Center gives such advice, and if so, to a limited extent. Other law firms or in-house capacities are not so much available for developing countries. And it requires also different ways of looking at the system, because before we were talking about forum shopping between different fora. What law firms, from my discussions nowadays do is they do forum hopping, as I called it, during different stages of the proceeding. So when there is a appealed panel report into the void, alternative dispute settlement mechanisms are used to achieve something out of it. We mentioned the legal capacity building that is required, but it's not only about how to learn to use the procedures. This is a chance to shape procedures that really respect the need of developing country and for special and differential treatment. And as we know, developing country specific provisions in the DSU are often soft law or merely request members to give sympathetic consideration to certain concerns. The facilitators package does not meaningfully reform that situation, because most of the newly proposed procedures are not binding. And even when the parties decide to embark on them, they can abandon them at any stage. Article 5 contains more elaborate mediation, conciliation, and good offices procedures, but achieve only marginally the objective of better integrating developing countries, because, for example, any party can opt out from these procedures at any time. The findings are not strictly enforceable, and according to the most recent facilitators draft report, mediators, conciliators, and good officers are not allowed to develop legal interpretations of the covered agreements of the WTO. They're merely expected to facilitate discussions or negotiations between the parties on a mutually agreed solution. It is difficult to see how is this supposed to work. I would join what Peter said about that it's something unexpected that you would even alternative dispute settlement actors to refrain from making proposals on what a legal solution could be. An alternative that is facilitated and encouraged are authoritative interpretation under Article 9 of the WTO agreement, which developing countries and LDCs possibly would be able to achieve with their quasi-automatic vast majority of the WTO membership. This presupposes, however, that developing countries speak with one voice to forge consensus, and this is not currently prevalent in the multipolar world defined by divergent interests. It is well known that panel appellate reports never enjoyed presidential effect. Peter explained his dismay about the explicit exclusion of such effect. This, of course, has also consequences for how developing countries can rely or use the system if they face a system where adjudicators would in each time have to develop their own interpretation and not necessarily can trust that similar cases will be similarly decided. The attractiveness of the system will suffer. We also heard about the rules of interpretation, maybe just one addition. I don't need to duplicate what Peter said about interpretation methods. The focus on supplementary means and negotiating history, mentioning, he already mentioned the absence of a binding one, also disadvantages developing countries that often acceded to the WTO after the treaties were concluded. So they were not sitting at the table, and in such a situation, it's possible, of course, to join a treaty, but you will want to go by what the treaty says with classic interpretation methods. You don't want to join a treaty where we're not sitting at the negotiable table and face interpretations by those or some or one that were sitting at that table. Most stunning from a perspective of developing countries, also this provision that was mentioned by Peter about the need to establish the existence of an obligation. It's clear that any party to a dispute needs to establish the existence of a breach. That's not unknown, that's typical. However, it should be the mandate of the adjudicator to have the last word on the existence of such an obligation. If it really depends on the skills of the complainant to establish the existence of an obligation, then developing countries or LDCs with less capacity could face the situation where they don't succeed in establishing the existence of such an obligation, while developed countries with in-house expertise do. That would further fragment the rule of law. It's difficult to predict at this juncture how the chapter on review of reports by relevant WTO bodies, the advisory working group, and the creation of an accountability mechanism would play out from a developing country perspective. The first thing, discussions in councils and committees are a positive thing because, as Ujjai Bhatia was saying, there's currently no mechanism for panel and appellate body interpretations to be discussed there. Maybe they could enrich committees' work, or maybe adjudicators could benefit from receiving comments on how these interpretations play out in practice in the real world. The advisory working group is a new feature, and it's quite interesting what it's supposed to do. It could propose an authoritative interpretation of the WTO agreement. It's called an authoritative interpretation, but it's almost like an amendment, even though technically it's not falling under the amendment procedures. However, it requires a 3/4 majority. Again, this would give developing countries speaking with one voice an almost automatic majority if they were to join forces. What is more new is a recommendation to the DSB to agree that the interpretation at issue shall not be considered as persuasive. However, the DSB operates, as was mentioned, by consensus, and the winner in the dispute is unlikely to join the consensus. The third option is to record the members' divergent views about the interpretation, which looks like a roll call on how much traction an interpretation bears. It would record the number of members that expressed the views, whether they were favorable or not, and their reasoning. In such a situation, it's difficult to see how there can be evolutionary interpretation, because such a roll call would be more a snapshot on the status quo. If you transpose that to the national setting, suppose the Supreme Court decisions are discussed in the Indian Parliament, so it's possible that both chambers, the Rajya Sabha and the Lok Sabha, they both will give a majority vote in changing the law. That's always possible. It happens in many countries. But as Ujjwal Bhatia was saying, in a WTO context, operating by consensus, that's hard to achieve. But at the same time, it's problematic because it basically may constrain the ability of development of jurisprudence and to adapt it to changing concerns in the society. The Indian Supreme Court has certainly a reputation, maybe less so in recent years, to have shaped societal changes. And on the one hand, you could see how this could work out, looking at the separation of powers from domestic setting, but it's hard to see how this would work at an international setting. Finally, the accountability mechanism is somewhat akin to the inbuilt DSU reform agenda that was already ongoing since 1998, and after a plethora of meetings has not produced tangible results. What is new here is this process would be revived, and it would be coupled with specific performance targets, but it remains to be seen what they will yield. All of this, these procedures could overlap, and they could, on the one hand, give rise to more power orientation by powerful members, putting pressure on independent and impartial adjudicators to revisit or refrain from adjudicating issues or developing interpretations. On the other hand, this mechanism could also offer new opportunities for a large number of developing countries and LDCs to make their voices heard in relevant councils, committees, the DSB, and in the reform processes. And finally, such procedures could offer an avenue to a litmus test whether a specific interpretation is considered erroneous or problematic by a large majority or only by a small but very vocal minority, be they powerful or not. In that sense, they could serve as a reality check for a vocal minority that the view of a few is not shared universally. I leave it at this. Obviously, this will not probably resolve the perceived imbalance between the quasi-judicial and the political branches of the WTO multilateral trading system. It has always been my view that you don't resolve this imbalance by weakening the dispute settlement branch. You can only work on better governance of the negotiating branch to make it work. A final word on the approach that was used by the facilitator, and he called very much in the paper that was quoted also by Peter. He followed an interest-based approach to negotiation as opposed to a position-based approach to negotiation. Some commentators have said that maybe amounts to the same, so some would say it's hot air. On the other hand, one would have to recognize that even though some fundamental parts, like the appeal mechanism that James will address, have not been touched, there seems to be no consensus on how to move forward on this one. But the text that exists is a text without brackets, and that's remarkable, because normally negotiating texts at the WTO are replete with brackets showing remaining disagreements. So that approach is meant to first define priorities, principles, and aims and interests without getting into detailed drafting and wordsmithing. Rather than insisting on negotiating positions, this approach focuses on uncovering underlying interests and priorities and exploring on whether they can be reconciled and resolved through achieving innovative approaches. Maybe, but only maybe, this could be a new avenue for developing countries and LDCs raising concerns and realizing their interests. At the same time, it cannot be hidden that such interest-based approaches also offer an avenue to power-oriented approaches by key players. Thank you very much.
Thank you, Professor Werner Dock, for bringing practical insights on the interpretation challenges in the dispute settlement processes, and again also for stressing on the aspect of different ways of looking into the system or the different stages of the proceedings from a developing country perspective. Now it's my privilege to invite Professor James J. Nedumbara, WTO Chair Professor and the Head of CTIL, IFT, Ministry of Commerce and Industry, Government of India, to share his views on the aspect of modifications or reforms that are necessary on the WTO two-tier process, and to compare probably whether there would be a scope for comparing the two-tier system with a single-tier dispute settlement system. Over to you, sir.
Thank you, Rosmi. And thank you, Center for WTO Studies, and also the Jeevan Reddy Center for organizing such an important discussion on a very lively topic. Since I'm actually following some of the very eminent voices in this particular area, I do not think that I have much to contribute, but I will definitely express my views on some of these issues. One interesting, so my topic is basically a comparison between the single tier and the multiple tier or the two-tier system. The two-tier system is actually the system that is already in place under the DSU. The single-tier system is actually a system that existed a long time ago, prior to the WTO, until 1995. And then there is another model which is actually a single panel system, and then we have got the Article 25 arbitration mechanism with a different model called the MPIA, the multi-party interim arbitral mechanisms. So we have got three models on plate at the moment. So when we think about this issue, I was actually looking at the debate happening in an entirely different area. That is actually investment. And especially with respect to ISD as investor-state dispute settlement. So if you really look at the developments happening in the UNCITRAL Working Group 3, they're actually talking about implementing a multilateral investment court and also an appellate mechanism. So this actually reminds me of the point which Dr. Preetham was mentioning in the point. You know, in international law or maybe in diplomacy, we actually go through cycles. The only problem here is that there's no synchronization. In trade, we are talking about going back to the old days. In investment, we are thinking about having a system that trade had between 1995 until 2019. And when we think about this issue, let me actually put it this way. So most of my, the previous speakers have been talking about the report of Marco Molino, and that has got some very interesting proposals at the moment. But the most important issue is basically Title 3, which is actually appeal/review. And again, there are some very interesting issues with respect to this point. If you look to Article 17 of the Dispute Settlement Understanding, it actually uses the term appellate review. And if you look at the outcome document in MC13 and also Marco Molino's report, it is written appeal/review. Some of us are actually bred in the domestic system. Appeal and review process are entirely different. So what is actually the distinction between the two? And again, we don't have much of a clarity at the moment. And if you really look at the outcome document, it says, as Ambassador Bhatia mentioned a while ago, the objective is to have a fully and well-functioning dispute settlement system by 2024. There is absolutely no further clarity on the nature of the dispute settlement system, whether it will be the old system, the original system that remained until 2019, or maybe even existing as of today, or will it be a different kind of a system? On these kind of fundamental areas, we do not have a much of clarity. And the Molino report mentioned that this is actually work in progress. So of course, it's a very interesting topic, and the Molino report has definitely covered a lot of ground in multiple areas. But this issue is perhaps, in my opinion, the most important issue, and it has to be tackled head on. So once you read, I think once you really look at the DSU 2.0, so many people said that if you really look at the developing countries, they all believe that the two-tier system is actually a well-functioning system. It appeared, it functioned for a long period of time, produced a number of very good reports. It's not actually good that the system continues. So that is actually one particular issue. But countries that really wants to retain policy space, right, who are averse to the idea of gap filling, who are averse to the idea of advisory opinions, who are averse to the idea of the entire concept of judicialization, said that a single tier system is actually better. And we have to understand, the core of the controversy here. The core of the controversy is actually to make sure that this system is an informal system. So far, this system has been judicialized and legalized. The judicialized and legalized system will have to go, and in its place, a system that is very informal, an ad hoc system will have to come in. So that is where, when we are looking at all these kind of debates, we are actually making a regressive step. It is by no means a progressive discussion. And that is why I actually refer to the discussion happening in ISDS. We are making definitely a regressive step here. So now, when we really look at the objective of the system, what is actually the objective of a dispute settlement system? To have a mutual resolution of issues in a neutral, impartial, and objective way. And in addition to that, we need to have the principles of consistency. We need to have the elements of coherence. We need to have impartiality. And the previous speakers especially spoke about the non-precedential value of reports and other things. These kind of ideas are basically eating away the edifice of the WTO system to an extent which guaranteed stability, certainty, predictability, coherence, all of these kind of really good values, which I would actually call as the rule of law values. So the rule of law values are basically eaten away by a kind of an informal system which is actually on the table. And now, the point is that if you really want to have a better system, we had a lot of discussions in the WTO. There was a walk-up process. There have been a huge amount of academic writings by various scholars in order to improve the system. But what actually happened? The system has been paralyzed, right? When we really want to improve a system, we will not actually kill the system to make changes to it. The old system has been killed, but still we are thinking about a system, the contours of which are fairly unclear at this moment. And my own feeling is that, so the two-tier system is actually the best system, but we are all actually, we have to live in the realm of reality. If the two-tier system is not going to happen in the future, then perhaps we may have to come to the single-tier system, or actually the old system. But can the old system be made really functionally good? We can say that it has to be robust in its nature. Sometimes the quality of that particular system has to be good. And one suggestion made by Professor Mavroidis and Bernard Hockman is that there should be a standing panel of experts. So in the sense that it will to an extent mimic the appellate body system, which is actually in place today, not in place today, but at least we have on paper. But that system will have an eminent list of panelists reflecting their expertise in law, diplomacy, or international business for that matter. And they can give an authoritative, kind of a report, which will come up with a robust, good, and qualitatively superior reports, which may not actually require a review. So let me put a point very clearly here. So when we think about judicial reasoning or adjudication, a number of people, I mean, of course, we are sitting in the midst of some judges as well. No opinion is actually infallible. Even when the appellate body sometimes comes out against a particular panel report, it is a different shade of thinking. So even the same kind of a provision can be interpreted in multiple ways. So it is very difficult to say that one way of interpretation is actually superior, but at the same time, the two-tier system is procedurally more robust in the sense that it actually, it is a much more inclusive process. It gives a second bite at the apple. And therefore, even an aggrieved party will get a chance to raise an appeal on the same issue. And even if the party loses the second stage, the party will be internally more convinced that my case was actually a bad case. Right? So when compared to the single panel process, the two-tier process has got some inherent advantages. But I'm not actually of the view that even if there are two layers of system, the reports will be qualitatively superior, because we are actually dealing with the laws, and everyone knows that laws are by its nature indeterminate. So when we can have a debate on what is actually public body, what is zeroing, multiple people can come up with a multiple interpretation for that matter. Sometimes it may be folly to say that one interpretation is actually superior to other. But when we have got a two-tier system, the process of going through the two-tier system will make sure that the aggrieved party will feel that, I didn't have a good case at the end of the day. So that way, it is a good system. And secondly, from a public policy point of view, when a country actually loses a case, let me tell you, since I've been working with the government, if it loses a case, it is a great excuse for the country to say that I'm going to appeal that decision. It actually gives a huge amount of comfort for the country, saying that the panel might have erred in the past. Even if I have got a weak case, I can at least convince my domestic constituency that I have got an opportunity left. And that way, it is a really good system. Although you may have a bad case, even an appeal process cannot actually redeem your conditions, but at the end of the day, you can go through another process. That actually gives a bit of comfort. So now let me come to the last point. When we read the Molino report, I mean, as Professor Vanden Bosch and all my previous speakers spoke about, it's coming up with some weird statements that a previous panel report cannot be persuasive. And everyone knows, as I mentioned earlier, laws are indeterminate. And even if you're hardcore positivist, when the laws aren't very clear, then we are actually entering the penumbra. There's huge amount of uncertainty. How will we resolve the differences? Sometimes we look at the body of law. Sometimes it may be body of practice. It may be different way of thinking. So any kind of a previous report given by, may not be even a WTA panel, maybe a third panel altogether, maybe a NAFTA panel, maybe some other panel for that matter, will be of some help to that particular judicial or adjudicative body. So that is why, even in the field of investment arbitration, let me tell you, there is no stare decisis. But if you read some of the most important investment arbitration awards, they rely upon cases decided in the past, not by the same agency, but by different agency as well. That is why. And secondly, the point, again, there are some issues with respect to interpretation. So even if a particular position is very clear, the Marco Molino report is actually saying that a panel will have to develop its own legal interpretation. I was actually going through one WTO case, very recent WTO case with respect to Article 21. I was wondering why the panel is actually doing this exercise, which was done in many other cases in the past. In a way, you're wasting judicial time. Every time you're developing your own separate, independent legal interpretation on a particular issue, you're not actually doing any great service. Sometimes that particular point might have been well articulated by a different panel in the past. Why do you have to develop it each time? So at the end of the day, I'm saying that to have a consensus on this issue is very difficult. And secondly, the last point which I want to mention here is that it actually talks about the advisory body and other things. But let me tell you, when a dispute comes to a panel, the panel will have to resolve the issue at that moment. It cannot really wait for the guidance of the WTO advisory working group to have an authoritative interpretation on a particular issue. When you actually have a particular case on hand, you have to resolve that matter there and there. At that time, you have to take recourse to report any kind of a judicial adjudicated ruling which can basically amplify or clarify your ruling. So that is why I find a number of problems with respect to the current approaches. But let me tell you, the most important thing is to have a fully functional dispute settlement system. And even if it is 1 tier or 2 tier, it is very important to have. It is very important to remove that paralysis or maybe the dysfunctionality from the system. So I'll stop here and thank you very much.
We are very grateful to you, Professor James Nedumbara, for sharing your analysis on the fundamental elements of WTO's two-tiered DSS and on the changes that may be necessary to allow the system to be fruitful again for the members. Now it's an honor for me to invite Mr. Atul Kaushik, retired Additional Secretary, Government of India, to share his thoughts on the question whether the process of reform, whether it should be formal or informal. Over to you, sir.
Thank you. And let me also start by thanking Justice B.P. Jeevan Reddy Center for International Trade and Business Laws of the Nalsar University of Law, the Center for WTO Studies of the IIFT, and Dr. Kapil Sharma in particular, for inviting me here and enabling me to interact with the young students of this prestigious institute. You've given me the topic of formality and informality in the process of reform. So I assume you are referring to the ongoing reforms of the DSU, but they have to be contextualized in the larger gamut of reforms that have happened over time. So I have a short answer as well as a long answer. And like Ambassador Bhatia, I'll give my short answer first, which is that it has to be both. But in the end, formalization is needed. Now let me start with the long answer. So the context, as we have been discussing since morning, including during the inaugural session, is that the WTO members, 130, including EU as one, and more than 150, including EU as separate 27 countries, want the appellate body to be revived. One country, US, opposes. Because US has concerns, and we have discussed some of the concerns today, and we are going to discuss them in later panels, so I'll not elaborate upon them. Except that apart from the US, the UR negotiators, the negotiators during the Uruguay round, also did not foresee the problems that they will face when China becomes a member, and the measures that China takes may allow unwarranted advantages to nations like China, particularly in respect of their state-owned enterprises and the definition of non-market economies. Now, in this context, we are having this discussion, which is being called as the Molina discussion or a facilitator discussion since morning. But let me call it the US-led process, because that is how it began back in April 2022, when the US on its own, outside the WTO, starting with outside the WTO precincts as well, but after then, booking rooms inside the William Rapport building, started having these informal discussions. And the discussions, as has been rightly mentioned by several of the speakers ahead of me, were based on what was called as interests and concerns of the members, or rather the delegates from the member missions, not even members. And because the ambassadors, for example, were clearly barred from entering those rooms. So these were discussions on interests rather than on positions. And Werner has given an elaboration of why sometimes interests have to be resorted to as a solution when position-based discussions don't move forward. But eventually these discussions have to convert into a decision. And for that decision, you have to convert these discussions into a negotiation. So how do you have a mandate for that negotiation? We've discussed since morning what MC12 asked the members to do. It was a discussion. But WTO provides a forum for negotiations, and that is decided by the ministerial conferences. They have the exclusive authority also to adopt authoritative interpretations, which Article 19.2 of the Marrakesh Agreement provides them, and that has also been mentioned earlier. And in case of amendments to the DSU in this case, a member would have to initiate a proposal. So let's assume the US is initiating a proposal based on its so-called interest-based initiative. And the problem is that unlike several other of the WTO agreements and understandings, in the case of dispute settlement understanding, the Marrakesh Agreement says that the proposal that is to be made to the ministerial conference has to be a decision by consensus. So majority doesn't work. Of course, majority has never worked, will probably never work in even those cases where legally speaking, voting can happen. But from a very legalistic point of view, DSU is a class apart for the simple reason that even a decision to negotiate has to come from the ministers through the ministerial conference decision by consensus, not by voting. The framework of such discussions that are mandated as negotiations also has to be decided by the ministerial conference according to the Marrakesh Agreement. Now, keeping this in mind, let's go back a little bit to the history of why this discussion today and not negotiation. You know, there have been mandates for negotiation and discussion prior to this US-led initiative. The Uruguay round decision on the review of standard of review of Article 17.6 of the anti-dumping agreement is a decision that was prescient in recognizing that this is going to be a problem provision and the members would have to take time to have an authoritative interpretation. And during the Marrakesh, before the Marrakesh Agreement and during the Uruguay round negotiations, they did not get to that authoritative interpretation. So they pushed it forward to beyond the Uruguay round. Not only that, a full review of the dispute settlement understanding was also mandated. And within 4 years of the coming into force of the dispute settlement understanding, the members were supposed to decide whether to terminate it or to continue it or to modify it. So there was a full-fledged mandate to do something about the DSU or that part of the DSU that they did not like, based on the experience of those 4 years. Unfortunately, rather than spending those 4 years discussing, they started the discussion in the 4th year and therefore could not complete it in time and hoped to get a mandate from the ministers in the second ministerial conference in Seattle, where all other mandates also failed. So it was a failed ministerial conference. Hence, this mandate from the Uruguay round days also kind of fell by the wayside. But then came the 4th ministerial conference and we had the Doha development agenda, and the ministers in that decision graduated this review into a negotiation. So explicitly, para 46 of the DDA says that negotiations are agreed on improvement and clarification of the dispute settlement understanding. So there was probably a realization by the ministers or by the member states by that time that elimination of the DSU is not an option that they are looking at, but modification and or whether to continue it without modification is something that they do want to look at, because there are some problems that they have with certain provisions of the DSU or the certain ways in which the stakeholders implement the provisions Considerable work was done based on this negotiating mandate. We did not which did not come to fruition, so there is no decision. And the mandate continues. There was a lapse, but then it was revived, and it was revived without any deadlines, unlike earlier. Therefore, strictly legally speaking, the negotiating mandate of the Doha round continues. Of course, whether Doha round exists or not is another question, because back in 2015, US TR said on the floor of the WTO that Doha is dead. And by 2017, several of the press that we keenly follow in this field started saying that Doha is dead. But if it is not, as is the legal position, then the negotiating mandate exists. Now, in this negotiating mandate, because of the lack of success of the negotiators, exercise continued to try and find some landing zones, to try and find compromises. And those efforts were in various formats. Formal, through the special session of the dispute settlement body, of course, but also informal. It was based on discussions which were plenary, but also discussions which were in group meetings. There were discussions which were bilateral. There were discussions which were called as chairs consultations. There were discussions which were led by champions. I remember the Indian delegation having been approached when I was in the mission to be a part of a group of 7 countries, 3 of them developed and 4 of them developing, to come together and come with a workable solution to finding landing zones for the DSU review. And we participated and gave some very useful suggestions, and in our bilateral conversations with the big players as well, did not find any oppositions to the proposals that the so-called G7 group of countries made. So what was happening here? What was happening here was informal discussions. But the informal discussions were being resorted to by the members because they wanted to eventually formalize this informality with a view to get a decision by consensus of the entire membership, and that could happen only when you have a formal negotiation. Now, if you apply, these informality processes to the current situation, what do you find? So one is that we have a conundrum of kinds where the report of the facilitator of this US-led process has been presented by the facilitator as the deputy chief of the Guatemala mission at the behest of the chair of the dispute settlement body by putting it on the agenda as a report that he is presenting. So going back to my proposition that a single member can make a proposal to the members to start a negotiation, is it a Guatemalan proposal that has come with a report by Baco Molina attached with a long consolidated text? Or is it the result of what is being called as collective understanding of the membership, when the ambassadors of those member countries were also not allowed into the room? Some specialized legal officers of some of the member countries participated. So that is a question that has to be decided. The other problem is that although it is being called consolidated text, the elephant is non-existent in that text. And James has mentioned that, and several other speakers before me have mentioned. Unless we decide whether there is going to be an appellate review or not, you're not going to be, I mean, you're not going to be able to satisfy the ministers when you reach the next ministerial conference, or even the ambassadors when you reach the next general council, that you have resolved all issues by having a 20-page document on how mediation or conciliation should work, or another 3-page document on how many words or how many hours should we spend in litigation in the WTO. You will have to address the main issue, and that has not even, I mean, there's not a single sentence. It says work in progress. It doesn't even state what is that progress that has so far been made in that work. So this formalization, therefore, would require some more backroom work on this so-called US-led process, or Molina as a facilitator, or consolidated text, whichever way we want to christen it. The first and most important demander of this should be logically the United States, because they are the one at the back foot in terms of 130 countries pumping at them every month in the dispute settlement body, and they're coming up with one sentence rejection of the proposal to appoint members of the appellate body by saying that their concerns have not been addressed about the functioning of the dispute settlement mechanism. There are another set of proponents which are in favor of the so-called multilateral, arbitration arrangement, the MPIA. US is not a member of it. India is not a member of it. But notably, European Union is a prime proponent. So another proponent that should come forth and come up with that proposal is to say that, okay, we are going to talk MPIA. There is a third set of proponents, not a single country, because each of those single countries is not big enough to bring a proposal, which is the set of developing countries. We have had various avatars of these developing countries over the time from the Uruguay round negotiations onwards, like-minded groups, or G77 plus China and so on. So maybe they should come forward with what are their special and differential needs. Clearly, as has already been mentioned by Werner, what is mentioned in the current chapter on accessibility is inadequately addressing what the developing countries are actually wanting to achieve through the modification or clarification of the dispute settlement understanding. Now, these are three, but there may be others who could formally or informally bring in these proposals in addition to whatever Marco has brought in, and come with a cluster of issues that can be discussed together by the entire body of WTO membership, rather than those who have, quote unquote, an interest, or those who have, quote unquote, a concern, but not allowing those who have, quote unquote, a position into the room. So if you take away those three positives and negatives for entry into the room, then probably you will have the critical mass necessary to take forward the negotiations. So maybe I'm taking too long, huh? So let me take 2 minutes to conclude. Informal discussions, they are beneficial in the sense that they don't tie delegations to a particular position at that point of time. They are exploratory, or they are considered exploratory. Formal discussions, on the other hand, even if they are happening in an informal setting of that formal mandate, tie you to the position that you have taken, of course, with the caveat that nothing is agreed until everything is agreed. So you have a position, but that position is contingent upon other positions also falling into the landing zone, and then only you come to a solution. So both formal and informal will probably then determine the landing zone. Keeping this in mind, where do we stand in the current debate about this formal and informal? So one is that, although Marco has gone, whoever comes as a facilitator will not be able to bring up adequate results for the simple reason that the problem that the developing countries were facing with the Marco process, or before that the US-led process, has still not gone away, which is that it is an informal process. Therefore, the WTO Secretariat never bothers to see whether the meeting that this informal process is having is clashing with another equally important meeting for those delegations, which are small, which represent more than one committee and council in the WTO, and therefore their concerns can be addressed in a room that is discussing those issues only if they are sitting there, and they can't sit in, at the same time in two different rooms in the building of WTO. That is one thing that requires to be settled. The second is, you will at some point of time have to bring in the position-based situation into the room, so that the interest-based discussion that has so far brought in some concerns onto the table edifies into positions that can then be determined to negotiate what the compromise is. So if these two elements are worked on going forward, I see the possibility of finding landing zones for DSU negotiations. But like Ambassador Bhatia said in the beginning, I don't see it happening in 2024 as the ministers wanted. So probably we'll need another mandate from the ministers. Thank you.
Thank you, Mr. Adil Kaushik, for helping us to understand the process of reform from various dimensions, including historical, geopolitical, or maybe from the Marco Molina report, or maybe from the views of ministers of the member states, or maybe from the experiences of negotiation, and so on. Now it's my pleasure and privilege to invite Professor Sheila Rai, Professor and Director, Center for International Trade Law, NLU Orissa, to speak her views on strengthening ADR, an effort to strengthen dispute settlement system or restoring dispute settlement system of GATT era. As we are running out of time, may I request you to quickly share your views, ma'am. Over to you, ma'am.
Thank you, Rosmi. The BB Jeevan Reddy Center for International Trade and Business Laws and IFT for inviting me on this for this panel discussion. No, the topic that I have been given, that whether bringing strengthening ADR will make the dispute settlement system pre-WTO or what it was in GATT era. So the substance of the topic is basically what I gather is that whether, as it was happening in GATT era, allegedly was that whether political influence and power play are being reintroduced in the dispute settlement system through the ADR process. So we are weakening the adjudication process by stalling the appellate body and bringing ADR and sort of reintroducing power play. Right. Now, any student of law knows that law itself is a political statement. So, and adjudication, whether it is national adjudication or international adjudication, has a political angle. Right. So, I mean, this is nothing new, starting from realist school to postmodernist. Everyone has, I mean, states, whether and legal theorists and international law, everyone states that there's somewhere there is a political influence and power play in the adjudication process. And of course, lawmaking itself is a political act, right? And nothing, I mean, the best example is agreement on agriculture, which is nothing more and nothing less than a political compromise. So so let us not, first of all, to start with, we should not deceive ourselves that we have to keep political angle out of it, and the adjudication process, we are introducing rule of law completely without being affected by extrajudicial concerns. Now, the as interest based thing was there, so the best explanation was given by Rusco Pound that law and adjudication, finally, it is a balancing of conflicting interest. And it is nothing, it's not true. If it is not true in international trade law and WTO agreements, it's not true anywhere. Right. Now, so what do we exactly mean by taking the adjudication, that by going back to GATT era, right? So now GATT era had some issues. One was that there was a lot of power play, and there was, I mean, to begin with, the legal system or the legal process in the GATT era adjudication process was very weak. So panelists would choose what topics or what issues they would be adjudicated upon, what issues will be set for political compromise, etc. Right. The other was that since the the GATT secretariat had very weak legal presence, so that led to a lot of faulty panel reports, and finally Arthur Dunkel established a legal wing in the secretariat. Now that led to the apart from other thing, it led to the development of analytical index, which partly is possibly responsible for what US is introducing precedent system, right? Now, other problem with GATT era was that it is a lot of panel reports were blocked because the influential countries, when they lost the case, they blocked the adoption of the reports, which then didn't have any legal binding. Now, the WTO adjudication process resolved, I mean, at least attempted to resolve these issues. One was that by bringing negative consensuses, we did away with the power play in the adoption of the panel reports. And the other was that to resolve faulty panel reports may have faulty legal reasoning, we created an appellate body for reconsideration, right? Now, but did we do away with politics altogether? No, because Article 3 of DSU clearly states that, Article 3 of DSU balances between legal certainty and legal predictability, as well as positive resolution of dispute. So the objectives given in dispute settlement system in more or less given in Article 3 is, one is to bring certainty and predictability to the international trade system, right? So that is, appellate body did this job well. There are other two objectives in Article 3. One is that members should apply judgment before bringing a dispute in WTO, and the emphasis should be on positive resolution of dispute, right? So it clearly states that if you are able to resolve dispute without adjudication process, that is more than welcome, right? And then this does not create misinterpretation, does not disbalance the balance of negotiation that are codified in the agreements. Another provision in Article 3 of the SU says that all solutions have to be in conformity with the WTO agreements, and they will not affect the rights and obligations of the members under the WTO agreements. Right. Now, whether we succeeded now in bringing the first issue, that is bringing legal certainty and predictability to the international trade regime, I think we all will agree that we have more than succeeded, right? That is sort of very well reflected in the trust that WTO members have shown in the WTO appellate body, because United States is more or less isolated on the issue. And it also shows the very fact that some powerful members are unhappy with WTO appellate body. That shows that more or less the appellate body, panels and appellate body have done have adjudicated the disputes with objectivity and impartiality. Now, will strengthening ADR system will take us back to GATT era again? Right? I don't think so. Right? One reason is that trade disputes are not only legal in nature; they have economic and political aspects as much as they have legal aspect. Right? So the this is the reason why before the adjudication process starts, there is a mandatory consultation system, right? So at consultation stage, I mean, the WTO dispute settlement system itself provides that you resolve as much issues you can at the consultation stage, and disputes fully or partially do get resolved at the consultation stage, right? Now, if we don't, right now we have provision for ADR under WTO, but it's not much used. But when we don't have a institutionally developed ADR system, then what happens is that we are mixing adjudication and ADR, right? So if we mix up adjudication and ADR, that makes dispute settlement more prone to political influence than keeping ADR system as a separate institutionalized system, right? And this would hurt not only the trust in the dispute settlement system, but also security and predictability that dispute settlement system aspires to achieve, right? So we should have a two-pronged setup. That is, we need to have a fully functional WTO adjudication system with panel and appellate body, but we also need to have ADR system where many disputes which do not require a sort of which go to appellate panel and appellate body because there is no properly set up alternative system, and it not only overburdens the appellate body, it also sort of uh, the it also allows opportunity for power play. So that way, if we can segregate the dispute. I mean, that of course the final decision will be with the members who bring the dispute to the WTO, whether they are taking it for adjudication or they are taking it for ADR. But then they can they can take. I mean, if an institutionalized system is there, many of the disputes may get where you do not need interpretation of treaties to adjudicate or when treaty interpretations are required to adjudicate to decide a dispute. So panel and appellate body or the normal adjudication process would sort of be helpful where we need interpretation of treaties, but we do not need this interpretation for resolution of all disputes, right? But then that the ADR system itself is not vulnerable to power play. We need that institutional system because the way panels of conciliators, mediators are selected, whether developing countries are represented in it or not, those needs to be set. Those need to be clearly set out in the rules that are supposed to be developed under the negotiations that are going on, right? The then they have the one issue that has problem when overemphasis in adjudication process is that many enthusiastic trade lawyers and writers, because the WTO adjudication process was doing very well, sort of they started campaigning about expanding the scope of those treaties, like bringing in environmental issues, human rights issues, talking about constitutionalization of WTO, right? So that is one problem, that if we have one or I mean that over emphasis on adjudication process and through interpretation process expanding the scope. That was one danger that the WTO adjudication process was facing. And I mean, it is like we have this crisis now, but sooner or later this crisis would have come if the appellate body, if the WTO panels and appellate body would not have exercised enough restraint to stop over interpretation, or to stop expansion of the existing WTO agreements by bringing in issues which were not which are not part of negotiated agreements. Right. Now, the issue, the other concern that has been flagged is that it will lead to forum hoppings, right? Now, but then that problem is not only for international, or will not be only there for the WTO adjudication process or WTO dispute settlement. It is there for national dispute settlement systems, other international dispute settlement systems also. So this is something that we have to live in, and this is something we cannot do away with, especially at this stage where the international trade regime and the legal framework of international trade regime is not so developed and not so stable, right? So that now one advantage of major advantage of having institutionalized ADR system would be that it will reduce the workload of panels and appellate body, because that was one complaint that has been giving, that they are taking a lot of time in adjudicating the disputes. And it would be better option rather than having word limits, the other proposals that are being given, like putting word limits, right? And like Anuradha was to speak on MPIA, but it's, as she's not there, like having a mixture of adjudication and ADR is a problem, like MPIA is a problem, right? Now, India is not a party to it yet, but then it is like, because ADR dispute resolution doesn't go to dispute settlement body for adoption. So a panel report may be partly appealed in MPIA. So part of the panel report goes for adoption, and part of what has gone for MPI need not come for adoption. So this type of issues will always be there in when you mix up ADR and adjudication process. So what I feel is that strengthening ADR system and institutionalizing it properly under the WTO system will help not only help to reduce the workload of the adjudicatory body, but it will also help to maintain the difference between issues that need proper adjudication and issues that need a negotiated settlement. But the challenge is that the panel that is there for for conciliation, mediation, they should not be from the secretariat, right? They should be independent panelists where developing countries are given proper representation, so their interests as such are taken care of. So it is high time, I think we need to we need to accept it that the politics and power play are not outside the WTO adjudication system, and they are not outside the legal system, WTO legal system. We accept it and create mechanisms how to handle it without compromising the security and predictability of the system. Thank you.
Thank you, Professor Rai, for sharing your thoughts on what we do actually need to do for balancing the conflicting interest and highlighting the significance of ADR, and again the challenges that probably could arise when we combine ADR with other adjudicatory steps. Now it's my privilege to invite Professor Shailja Singh, Consultant and Associate Professor at CTAL, to share her views on optimizing WTO panel procedures, enhancing efficiency, composition, and diversity. Over to you, ma'am.
Yeah, thank you so much. I hope I'm audible to everybody.
Yes.
Yeah, great. So good afternoon, everyone. Many thanks to Nalsar University of Law and Center for WTO Studies for this opportunity. It's a great pleasure to be part of such a distinguished panel. I have been requested to keep my intervention very, very brief. I will try my best. I have to admit it's not one of my strengths. But without further ado, let me get to the topic that has been allotted to me, which is WTO panel procedures. And if you look at the facilitator's text, which I should begin by again clarifying that it does not represent the views of the members who were able to make it to these meetings and these discussions. So absence of brackets should not be taken as any indication that it has endorsement of the WTO membership. But if we look at the facilitator's text, the title 2 deals with panel proceedings. It has 4 chapters on establishment, composition, streamlining panel procedures, and conciseness and time frame adherence. I would be focusing more on the panel composition part because the key elements in the title that has been allotted to me deals with composition and diversity. But for those of you who are not familiar with the other elements in the text, what the facilitator's text attempts to do is really to come up with ways in which the panel proceedings could be more streamlined, it could be made faster. And to do that, what the text basically proposes is to have different categories of case, which would then lead to determination of what would be the word limit, what would be the time limit for oral submissions, and so on. And while the intention appears to be quite, the need of the time, given how in the past panel proceedings have dragged on for extended period of time, the solution that is being presented, which is in the form of mandatory time limits and word limits, and adding these additional layers to the process in terms of determination of what is the nature of the dispute and so on, would perhaps make the process even more burdensome for countries who are not very well averse with WTO's dispute settlement system, who have limited capacity, and who do not have the essential technical expertise or experience in dealing with the system. So it does come across as something that would benefit the more frequent users who are more familiar with the process. Getting to the panel composition part, diversity and inclusiveness in panel composition has been an issue that has been raised by several WTO members who have been participating or who have been following these informal discussions. We can see this in the statements that have been made at the DSP, the statements that have been made at the ministerial conference, as well as some of the written submissions that have been made to the DSB and GC. The most recent of which was in February, when 5 developing countries, including India, provided their reflection on the substantive issues of the text. And again, one of the key elements that was highlighted there was this issue of having a more diverse panel as we move forward. So what does really the text say, the facilitator text say about diversity? It basically states that members should promote gender balance and geographic representation when they are making nominations to indicative list. It proposes a numerical limit to how many members, experts can be nominated by every country to this indicative list, which is 3. It could be relaxed by 1 if the person also nominates a non-citizen, and so on. But the key factor over here is that the diversity issue is still being given a very, very soft-handed kind of treatment. There are some limitations in having, mandatory diversity provisions at the panel stage, and that is something I will reflect upon towards the end. But we do have, some precedents in some of the other international courts, even if we look at the appellate body, which talks about there being a need for a representative balance. This is contained in the preparatory committee for the WTO's decision, which was approved by the DSP, and it called for representation from different geographical areas, levels of development, legal systems, and so on, when the AB was to be constituted. So these kinds of guidance is there in other contexts, but we don't really have something very, very concrete when we are talking about the panel stage. But the big question really also over here is that, do we really need more diversity? What has really been the track record of WTO panels when we are talking about diversity? And what really is diversity? So we are really looking at a representation from different geographical areas, levels of development, legal systems, and also gender. If we look at geographical representation, what we really see is that out of the 810 or so panelists, and this is a calculation that we had undertaken, late last year, almost 570 of them are just from 17 countries. Individuals only from 63 WTO members have served as panelists till date. And if we look at the numbers or representation from developing countries, we've had only 4 panelists out of the 810 panelists who are from LDCs and 432 from developing countries. So more than half of them are definitely from developing countries, and perhaps we can give some credit to DSU Article 8.10, which provides a provision for having a developing country panelist if the dispute involves a developing country party. But if we look at the distribution among the developing countries itself, then what we really see is that panelists from 1 or 2 regions really dominate. We have panelists from the group of Latin America and the Caribbean, the GRULAC, who have 249 of these 400 odd panelists. The Asian developing members have 105 panelists, and the African group is extremely low with only 66 panelists. Even there, we have 42 panelists just from one country. If we look at a regional group mapping, and these are regional groups which the UN follows for some of the dispute settlement systems, what we see is that 39% of the panelists have been from West European and other states, and 30% from Latin American and Caribbean states, and the remaining from other countries, or rather other regions of the world. If we look at the the legal system data, what we see is that 390 panelists have been from civil law system, 211 from common law, 207 from mixed law system, and finally, if we look at number of panelists by gender, 663 have been male panelists and 150 have been female panelists. There have been, I briefly touched upon this earlier, international courts and tribunals outside the WTO, for instance, the International Tribunal on the Law of the Seas, the Rome Statute of the International Criminal Court, etc., do provide for some kind of mandatory diversity provisions. But when we are talking about WTO, and that too at the panel stage, there are certain limitations. First is, of course, the panels are not a standing body, unlike the appellate body, where it may be more easy to implement diversity-related measures. And second, when we are talking about panel composition, the final say, or the discretion as to who would be a panelist is really with the parties to a great extent. And this is an important element of party control or member control that is exercised during the panel composition, which we would not want to dilute in any way. So the big question then is that when developing countries are seeking greater diversity, what can really be done? And one of the avenues that could perhaps be strengthened is the indicative list or the roster that's there. We might question the utility of the roster and how often it's used. If we look at the past practice, the DG has used the roster 166 in appointing 166 panelists, although 341 has been appointed from outside the roster. Even the parties have nominated or selected panelists from the roster in 63 cases as opposed to 165 from outside. So while it's not the majority of the cases that the roster is relied upon, but still it's not insignificant. And therefore, it is important to make the indicative list itself more balanced. Perhaps it could be explored if the indicative list could be mandatory for the DG to look into. There are ways in which the indicative list is being strengthened or proposed to be strengthened in the facilitator's text itself. It could also be explored whether the indicative list could be made mandatory for the secretariat unless instructed otherwise, by the parties when they are requesting suggestions from the secretariat. So these are all ways in which we could look at having a more balanced and diverse panel. Of course, in the final composition itself, the parties could be encouraged to keep these factors at the back of their mind. But the indicative list could provide a good first step or avenue in leading to the end goal of having a more diverse panel. This is an area which the text currently does not, the facilitator's text currently does not deal in much detail, but perhaps it is something that would be taken up later, given the interest of several developing countries in this particular area. So with that, thank you very much, and I look forward to any questions or comments.
Thank you, Professor Shailja Singh, for giving us a very coherent overview about how we can go for optimization of WTO panel procedures from the point of view of efficiency, panel composition, and diversity. Now it's time to take some of the comments that we have received online. We have comments from Professor Abhijit Das, and I take this opportunity to welcome Professor Abhijit Das to the conference. And now I invite Ms. Kandida Tiwari to read the comment for all of us.
The question is for Dr. Rena that there are no square brackets because dissenting voices were not recorded by Mr. Molina. So absence of square brackets is no big achievement. And then he also goes on to write that also it may not be fully correct to state that since there exists a divergence of views on the AB, hence it did not figure in the Molina text. On most of the issues in the Molina document, there is no consensus.
Thank you, Professor Das, for that comment. We have noted that. So any of the panel members would like to respond to the comment, we can do that. Maybe.
I think it's certainly correct that I think it's a valid point to say that that text doesn't necessarily prove consensus among all the delegations. I would qualify that answer, however, in two ways. Also in previous DSU reform negotiations, they were done at the level of specialists from the DSB delegates. It was never done by the ambassadors. And I think that's a good thing because I think the politicization of the process was a concern. And just as a footnote about the last presentation, where we talked about the selection of panelists, I don't see it as an advantage that the quality of panelists will be judged by the DSB chair, not by some independent body. As far as I know, in this off-campus process, there was a vast participation of more than 50 delegates from members. What is unknown is to what extent they were following instructions, whether they followed interests advanced by themselves or by their delegations. So there was quite diverse participation in drawing up this text. That is a fact. And I would assume that many of these delegates have coordinated with the delegations or with capital in what they're putting forward as an interest. And later on, when drafting sessions happened, as far as I know, it wasn't an open process. So The Secretariat wasn't present, but certain chapters were drafted together by delegates with Marco Tullio Molina, not only himself taking the pen. And of course, the notion whether it's true is a question, is that once you have defined the interest, priorities, and principles, the drafting process is less position-based. It's more based on whether the agreed principles, priorities, and so on have been put on paper. However, I would qualify that again. One thing, and that's a criticism of the current text, is it doesn't even specify which parts of it. I mean, it's very rare in the text that it says we need to change a particular provision of the DSU. So Marco was telling me it was an intention by the group to leave the question on what would require an amendment, a change of the DSU, or what requires no change to a later day. And that, of course, is maybe a good way to move forward with the text without brackets, but it somehow passes on the problem to a later stage. Because once you have to put it into the system as it stands, it will be a difficult process to see what requires amendments, interpretations, or whatever.
Thank you, Professor Van Dock. Now I see that Professor Van den Bosch has raised his hand. Over to you, Professor Bosch.
Yes, I would like to emphasize that the Molina report was incorporated by the chair of the DSB in his reporting to the special meeting of the General Council in mid-February. And in concluding the report, he says that he incorporates the report of Molina at his responsibility, his own responsibility. Now, if you go to the report itself, Molina's report itself, and I already cited this, it says that Molina says that the report reflects, or the text, of the draft decision reflects, and I quote again, the collective understanding and expectations regarding the system's operation. Now, 135 WTO members participated in these discussions. Undoubtedly not all to the same degree and with the same intensity for reasons that have already been explained. But I find it hard to believe that these dispute settlement delegates were just talking and voicing their own interests, their own concerns, without backing of capital. So I think we should give, and to some extent I regret that, because there are things in this draft text that I don't agree with, but I think we should give this text a lot of importance, a lot of significance. This will be the basis for further talks. I agree that once one is in a formal process, other objections may be made. Disagreement may re-emerge. I agree with that, but I would not de-emphasize the importance of the results that are already reached.
Thank you, Professor Bosch. Now we are running out of time, so I understand that you might have many questions, but our panelists are available after this session also. So I urge you to interact with the panelists probably after the session. I thank all our esteemed panelists for sharing their views, experience, and wisdom with us. We hope that this effort, together with the future ones like this, will help reinvigorate and broaden intellectual engagement with the world trading system, which, notwithstanding its imperfections, is a collective achievement worth praising. With that note, I declare that the panel discussion is closed. Thank you all for your patient hearing.
I really hope that was an interesting session. We'll now break for lunch. Before going for lunch, for all the participants, there are 2 registration desks which are set outside, one at the end of this door, one at the end of this door. Please use both the pathways and get your participant IDs as well as your conference kits. Along with that, please also cross-verify whether your paper has been sent to the OCID. In case it is not, please do that ASAP. Along with that, the lunch will be served in CC itself. The lunch will be there till 2 o'clock. However, because we have the technical sessions also starting at 2, please make sure you finish your lunch quickly and come back. We will not be entertaining any delays. There is a strict attendance policy which we are following. And from now onwards, there will be OC members who will be taking attendance. So please make sure that you don't go out and roam around in the campus while the sessions are going on. Additionally, for the lunch will be served for the panelists inside the dining hall, and the participants are not allowed to enter there. You will be receiving your lunch at the CC lawn. You will have Anirudh outside who will be escorting you to the CC. And the technical session starts at 2. In case there are people who are yet to send their PPTs or papers, please do that before 1:30. Otherwise, it will become a little problematic to accommodate any other changes of requests. And you can reach out to the OC or your POCs in case you have any doubts or queries. Thank you so much.